appreciate the time to speak on this bill. And I wish I had more time. We're just back, and this is a very serious piece of legislation, and so is the next one, the Mental Health Act, and it takes a lot of reading. I want to thank a lot of people. I want to thank the Digest, who once again under pressure produced a digest. I want to thank the work of the Justice Committee, and I want to thank in particular Deputy Pringle today for organising a presentation in the AV room with eminent people who, with nothing to gain, put information before us, and I want to thank all of them for that. Let me start on a positive note, because I'll certainly be going on to a negative note in relation to the abolition of juries in the High Court. And I would say that the actual rationale behind that is absolutely contemptuous, and the arguments that I've read are absolutely contemptuous of the ordinary person, and a complete failure to recognise the importance of the citizen or the resident of Ireland taking part in court proceedings, be that as a concerned environmentalist or in relation to making submissions on planning applications that end up in court, and certainly in relation to this and protecting one God's name. The abolition of the jury on spurious grounds that there's no evidence for is worrying. It's particularly worrying, and I'm going to go through some of it as best I can. In relation to being positive, I welcome the bill in that it's going to look at put a special section on slaps, which is very important. Sections 9 and 10 that the Minister has outlined, the offer of amends, and particularly the requirement to place the apology in the place of prominence. Equally, that applies to the judgment as well, that it would be a place of prominence. And there are many other good things in the bill that I welcome, but I will find myself in a position of voting absolutely against this on the basis of the abolition of juries, which has already been said is based on corporate interests without evidence. And I've repeatedly said Science Foundation Ireland have hauled us in to the AV room on many occasions to tell us the importance of evidence-based policy decisions. But that goes by the board on many occasions in here because we follow a particular pressure group. We followed it in 1988 when we abolished the juries for personal injuries, and awards did not come down, and neither did the cost of insurance. So here we are now, and we're going to abolish juries in High Court actions to protect, in an action where the plaintiff has brought an action to protect his good name. And I'm going to start by quoting in his open, and the digest again on page 28 outlines clearly, amongst many other matters. It says, in his opening statement to the Joint Committee during the PLS of the bill, the Honourable Mr Bernard Barton, a retired High Court judge who presided over defamation actions, warned that the proposal to abolish the legal right to trial by jury in High Court defamation actions represents a far-reaching and fundamental alteration in the law which, if enacted, carries with it serious consequences not only for the legal rights of any citizen or corporation bringing defamation proceedings to recover damages for injury to his or her good name, but also for the administration of justice. The primary consequences of the proposal are inherently undemocratic. Another legal academic who was with us today in the AV room said the department's chosen path would render this jurisdiction an outlier in the common law world in removing juries in their entirety from defamation actions. Now, I'm going to come back to the judge in a minute, but I'm going to go through the other submissions in relation to their views on the removal of High Court, removal of juries. And just what are we talking about here? We're talking about the Defamation Act 2009 that's about to be amended and changed, and that set out the definition of what a defamatory statement is. And it's one which tends to injure a person's reputation in the eyes of right-thinking members of society. And equally interesting and important and significant is that the presumption of damage recognises the difficulty or impossibility of proving the effect of one's reputation in society or community of a defamatory statement. And so we have various submissions. So we'll go to the Bar of Ireland, the Law Society, the Law Library, and they tell us on page 2 and 3. First of all, again significant, inevitably where reform of defamation law is contemplated, the media will probably contribute, and rightly so, in the context of making proposals for reform. However, one important practical point is often lost sight of is that the majority of defamation claims are made in proceedings which do not involve any media outlet. The most significant proposal, they said, is to abolish juries in civil actions. And they point out that the proposal runs contrary to the long-standing jurisprudence regarding the importance and value of members of the public being called upon to determine issues with regard to damage to reputation and the freedom of speech. That's the Council. The Law Society of Ireland, we disagree with this proposal, the proposal to abolish juries in the High Court, and maintain that juries should be retained in defamation actions in a very succinct and relevant submission. In relation to the cross-party committee on justice, and you know, there's a great absence of those members here today to speak to such an important issue, and I never like to personalise matters, but this committee is extremely important. It's a cross-party committee, as you well know, Minister, to scrutinise legislation before we pass it here in the Dáil. I don't have the privilege of being on that, so I struggle to understand and read. And I go back to what their recommendations were, and they made 18 recommendations. And number 1, cross-party, the committee recommends that the proposal under Head 3, which was the heads of the bill at the time, which you have put into the bill, to abolish juries, the proposal to abolish juries in High Court defamation actions should be removed. And they make 17 other recommendations, which by and large have been ignored. They welcome various aspects as well, absolutely ignored. So you'd wonder why we have cross-party committees to tease things out. And I wonder where those members are. I think Deputy O'Callaghan is on that, I think, and correct me if I'm wrong, and he was here today and he made some very interesting points. And I gather from what he said, although it's sometimes difficult to make out what government people are saying, that he thought the proposal to abolish juries wasn't acceptable. Now, again, I'm subject to correction. That's what I heard him saying. And I'm wondering then, as a member of Fianna Fáil and a possible future leader, what influence has his opinion on the Fianna Fáil party? Are they going to vote for this to abolish juries in the High Court, even though their spokesperson on justice is saying this is wrong? We talk about disinformation and we talk about the importance of communication. And all of this is a narrative that's based on nothing, based on saving costs, contemptuous of the ordinary person on a jury because they can't cope with big sums. Well, it would seem to me that the government is a particularly good example of being unable to deal with a big sum that we're getting from Apple. They don't know what to do with that money. They have no idea of what to do with the size of that money. And yet we have a narrative that the ordinary person is not able to do that. I would think that the ordinary person is best placed to decide if a person's reputation has been reduced in the eyes of the community. In relation to and I think it's worth going into the submission by the former Judge Bernard Barton. And he made this, and the reason I'm going into this is because there was an expert report that you're now acting on to abolish juries. And that expert report is the first report, actually, with all the various reports and committees up to now that actually recommended the abolition of juries. It never happened before. So it's a fundamental, I would say, a catastrophic change without any basis. And again, I just want to repeat before I go into this submission, my experience since 1999 when I was elected as a local councillor, and again, I apologise for making any references to that because one gets bored, I even get bored myself. But the reason for I mention it is I watched the systematic undermining of public participation in every aspect, local authorities and at the courts level. And I've had 25 years of seeing that, everything from the removal of power in relation to waste management, water removed, and very little, nothing left really for local authorities or members except in relation to a development plan and a budget that's carefully choreographed. We reduced the public's participation in the planning process, all based on absolute nonsense that people are objecting. My experience is that people take huge effort to make submissions because they are concerned. And any system, a planning system, a judicial system, should be robust enough to deal with those submissions, which are not objections. It takes a great effort for people to do that. And what did we do? We abolished the two-part system. So if you didn't make a submission at local level, then you couldn't appeal to Bord Pleanála. We've put every single obstacle in the way of public participation, although the courts have repeatedly highlighted the importance of the trinity in planning law. The courts, the developer, and the ordinary person. A trinity, normally a trinity is sacrosanct, but no, we keep demonising the ordinary person and going with a narrative that the government has gone with from the expert group. And in relation to that expert group, it didn't take account at all of the Supreme Court decision, which I understood came after the publication. I'm not sure because I haven't had a chance to check. Depending on where I'm reading it, the Supreme Court judgment came very shortly after the publication of the report. Whether it came shortly or longer, I thought there would have been an onus on that committee to re-look at that. I mean, that's what the process is about, isn't it, of consultation, to re-look at the recommendation to abolish juries based on juries are reckless, volatile, unpredictable, costly, and delay matters. And so the Supreme Court, which I'm sure you're very familiar with, Minister, probably more familiar than myself, set out in Higgins versus the Irish Aviation Authority, which ran for a few years, and eventually in the Supreme Court, they set out guidelines and parameters which must be henceforth applied to a jury in a defamation action. So the very mischief that this bill is setting out to achieve has already been sorted out. On top of that, as was pointed out to us by the former judge and other members that made a presentation today, they said to us that the special review group, based their decision or a lot of their findings on a number of cases that had nothing to do with the 2009 Act. They were actually dealing with the Act prior to that, the Act from the 1961, whenever that Act was, 62. And didn't take cognizance of the Supreme Court. I agree with the judge that it represents a radical departure from a long-settled public policy that lies behind the legal right of the citizen to trial by jury. Namely, that fact-finding in serious criminal and civil cases, and it's a serious matter in relation to your good name being taken away. Indeed, that's all we have as politicians, actually, is our good name, and that's rapidly being eroded. And other people as well, a good name. Where possible, it should be determined by a jury. And that judge goes on to outline that as far back as the Magna Carta in 1215, when citizens really had very few rights, they still saw the importance of putting in the individual rights and the trial by jury. Again, why? Because it became associated as a bulwark against the arbitrary misuse of authority, and the exercise of which ultimately led to the inclusion of the right to jury trial in the Magna Carta as far back as 1215. I'm reliably informed again that we had a Magna Carta in Ireland after that. And I'm going to quote from the judge's submission, which is unusual for me, and from the 18th century jurist Blackstone. He defended and justified the concept of jury trial in civil matters as the best preservative of English liberty, for it had the distinct advantage of protecting the citizen against the judicial caprice. Now, we know that judges are there's a lot of variation in judges, as there are in barristers, as there are in politicians. And it's ironic that it's the judge and the barristers and the solicitors are appealing to us not to abolish the juries. So I'm here today to say, have a relook at this, and also have a relook at putting a bill before the Dáil where there's amendments to come in the future, important amendments, which we won't have barely a chance to look at. I would also ask you to look at what the Irish Council for Civil Liberties has said, which is don't abolish the juries, but they've made very other important points, one particularly in relation to the civil legal aid. Again, no action in relation to that whatsoever. So I'm going to finish by saying I wish I could support this bill. I think there are a lot of good things in it that we need to pass, but once again you've put in something that I cannot possibly support. You have ignored the rational and very reasonable, and if I may say so, intelligent submissions from the various groups that came before you, and you've based your decision to abolish juries on an internal review that is selective in the cases that it chose, selective in that they're either before the 2009 Act or after it, but came under the De Rossa judgment, which is the same year as I went into politics, which set out a particular guiding principle that was finally undone by the Supreme Court in the Higgins case. None of that is reflected in the review that you're basing your actions on. So, Sinn Féin, Garamag.